Well, H-1B Modernization Rule was brought by Biden administration on January 17, 2025, at the last leg of before they left, just 3 days before the departure of the Biden administration. The modernization rule consists of 4 or 5 prongs. There are 5 prongs. One would be it strengthens the FTNS site visit protocol. It codifies. On the other hand, it also expands the definition of CAP-exempt nonprofit or research organizations, which means a lot more people will be eligible to file a CAP-exempt H-1B through these institutions, research institutions. The definition has been kind of widened out. So that's the other benefit of this H-1B modernization rule. Now, what are the negative impact of the modernization rule? Let's explore these also. So, prior to the arrival of the H-1B modernization rule, we used to go under the H-1B visa processing used to go under both the Biden administration as well as the Trump administration had Newfield memo on IT-Serve Alliance settlement. So under these 2 prongs of the settlement, employer-employee relationship has to be proven, an itinerary has to be given. So both of these has been now eliminated. Now, in lieu of these 2 prongs, an employer has to prove there is a bona fide job. The H-1B employee has been offered a bona fide job. So that is a very vague and broad definition of the requirement. How are you going to prove that bona fideness of the job? So if you are employing the employee in an in-house role, you must provide to the USCIS your incorporation certificate, your lease, bank statement, tax return, quarterly payroll, and if it's a software company, maybe a product or project description for the entire software development life cycle. How the research is going to start, design, developing, testing, coding of these applications using certain technology and tools. It has to be, detailedly written. So those kind of requirements has arisen due to the H-1B modernization rule. Now, if the client is sending, the employer is sending the H-1B worker to the end client side, how are you going to satisfy the H-1B modernization rule of a bona fide employment? That is also a difficult question to answer, but let's explore whether we could meet this requirement by this way. How about if the LCA has an end client name? Person is going to work at the end client site, is being paid a prevailing wage for that location. An LCA job posting was posted at that job site, at the client site, I meant. So if you have met these minimum requirements, now you could send the guy down there to work. But you got to also convince the immigration this end client site does have a bona fide job available, a specialty occupation job available at the end client site. How are you going to prove that, right? You might have signed a contract, you might have a purchase order, or you might be able to get an end client letter which states the job title, job duties, duration, location, and the required qualification to perform the job duties. So long as you can meet this threshold, the H-1B should be approved. And you will be satisfying the H-1B modernization rule of January 17, 2025.